and thanks to the Events Committee for inviting me here to speak today. I'll just fire that up. Okay, now look, I've obviously done quite a bit of research into drones, and I get emails every single day about drones, stories from right around the world, and every single day it blows me away, the new applications for drones, and they're limitless. And the figures it depends which source you look at, but the figures that they're talking about is it's going to be like the dawn of the internet era, and over the next 5 years it's going to become an $85 billion industry. And as you can see on the slide there, some countries are well advanced in their use of drones, particularly in the ag space. As I said, 90% of crops in Japan are currently being sprayed by drones. Google, Amazon, Domino's it's going to be amazing. You're going to have your pizzas delivered by drone in a few years' time. So the applications are absolutely limitless, and they will be an increasing and enhancing part of our day-to-day lives. But obviously they've already started to cause considerable issues in Australia. There's been, just this year alone, there's been 2 incidents where like civil aviation planes coming into land at Perth and a helicopter in Newcastle narrowly avoided hitting a drone at the height of about 1,200 metres. And this is one of the areas of concern, is this friction between general aviation and drones. And in the US, Congress decided in 2012 to task the FAA to come up with or speed up the regulatory regime for integrating drones into the US airspace by September 2015. And the FAA has already come out and said, we're not going to meet that timetable. So it blows my mind as to how they're actually going to integrate them into what is the world's busiest airspace. But anyway, that's the Americans' problem, and no doubt we'll follow their lead. And obviously, whenever you get new technology, you get people wanting to exploit the technology. And as Jerry alluded to, there's some groups, particularly animal activists, that are looking to use these drones for their increasing their social media campaigns. Now, there was a gentleman out here earlier this year, a journalist called Will Potter. He was sponsored by the animal activist group Voiceless to come out and give lectures. He actually started a Kickstarter crowdfunding campaign to buy a drone in the US, and he was seeking $30,000 in funding. Now, that campaign was fully funded in 5 days, and it's actually reached $75,000. I was looking the other day, it's moving towards $95,000. So they're going to get about 3 drones to cover off on US intensive farming activities. So it's something that we all need to be worried about. Now, obviously for everyone here in this room, they'd be well aware of the ABC landline program last year, where Animal Liberation made it clear that the feedlot sector is an area that they will be increasingly targeting. Mark Pearson of that group said that their legal advice was that if you're no nearer than 10 metres above the ground and you're not filming in anyone's houses, you can go ahead. And look, over the course of a major heat event in January this year, that threat was actually carried out on a New South Wales feedlot. So this is our new reality. And what should we be doing as an industry, and do we have any grounds to push back? So the first area or the current state of the law, and I'll talk about 3 areas, but the first one is airspace intrusions. Now, this is an area that goes back many, many centuries. As I said there, the guiding maxim, and I won't quote the Latin, but it's for whoever owns the soils owns to the heavens. And this is probably a case of my misspent youth watching too many cartoons, but you also, the maxim applied to the soil below your land as well. So I presume that meant, because I remember in all those cartoons, if you kept digging a hole, you ended up in China. So I don't know whether that means you have a 1/4 acre spread in China somewhere as well. But the seminal case in this area is this case called Baron Bernstein of Lee, who was a gentleman who owned an estate in Kent in the UK. And Skyviews was a company that had owned small planes, and they would fly over these grand estates, take photos and try and sell the photos to the landowner. Now the good Baron was pretty pissed off with this, and he sued Skyviews and said, you've impinged upon, or you've trespassed into my airspace. And basically this case, it once and for all abandoned the ancient notion that you own the vertical slice of airspace above your land. Basically what the court said in that case was that when a small aeroplane, that any aircraft flying over your property needs to, if it affects the owner's ordinary use and enjoyment of the property, it's not considered a trespass. So use and enjoyment is a term that I'll keep coming back to repeatedly. Now, the justice in that case, and I won't read that quote to you, but that's basically what the judge said. So you've got to remember this case is from 1979, and if you can pick up a couple of themes in that quote there, that he's talking about issues of privacy, and he's also talking about issues of nuisance, and I'll come to those shortly. But even in 1979, he's sort of leaving the gate open there for an expansion of this area of law. Now look, the Australian Law Reform Commission has recently handed down a report, and I'll get to that topic as well very shortly. Now, look, as I said earlier, Animal Liberation have a view that, if you anything above 10 metres, they're safe, and I don't think the law is as simple as that. And I think if someone was to take a case before a court now, there might be a different determination reached. Now, as I said, we'll move on to the area of nuisance. Now, this is probably a bit more fertile ground for commencing an action. These cases readily, or sort of traditionally, were grounded in the sphere of people living in built-up areas or industrial areas, and the factory next door spewing out foul odours or dust or unacceptable noise. Now, from our perspective, if we're looking at drones, there's a clear physical danger from drones, and I add here that a young man was actually killed in Brooklyn, in a Brooklyn park last year when he was decapitated by his model helicopter. So they're not things to be trifled with, and there is the real danger that, from a feedlot capacity, a foreign object flying above the feedlot might spook the cattle, and it sort of provides the perverse outcome that there might be an adverse animal welfare issue being caused by the people there that are there apparently to look after the cattle. So when the court looks at cases of nuisance, they look at a number of factors. Number one, you actually have to be the owner of the land or have exclusive possession of the land. There must be a substantial and unreasonable interference with the use and enjoyment of the land. I keep coming back to that term. And you can see there on the slide, there's a number of things they take into account. The locality of the land. In this case, we're going to be dealing with a lot of rural areas, which doesn't really bode well for having a successful prosecution of a nuisance action, but it doesn't mean necessarily you won't have a case. The duration here is going to be an issue, clearly, because we're not going to be talking about a sustained action as such. The drones will be there for a fleeting period of time. That doesn't mean that you don't have a cause of action, though. You need to show that there's malice on the part of the perpetrator, and I think that'll be pretty easy to make out here when you're dealing with animal activist groups. And in issues of, particularly because we're talking about noise, really will be the action you would ground the nuisance in, and it needs to be a substantial interference. So it's not a simple proposition. I think ultimately if you were going to go down the path of trying to start a nuisance action, you might end up being successful. You might win the battle but lose the war, so to speak. You'll spend a lot of money and not get a lot of relief. So then if we move to issues of privacy, most people are a little bit surprised to hear, because people just say, oh, it's a breach of privacy. But privacy really, from a Commonwealth Privacy Act point of view, only deals with data protection as its core driving principle. So it's really about how government entities and large corporations deal with the data they collect from you, rather than actually trying to protect private citizens. So, as I said, when people think about privacy, that's they've sort of come a bit of a cropper there in terms of thinking that this is a breach of privacy. But I will get to that topic in a little bit more detail shortly. Now you can see that quote there. That's from that's what the court's view is. There is no right to privacy in this country at the moment, from that 1937 decision there, and it's a pretty pithy little observation there from the High Court. So from 1937 up until 2001, it was very clear there was no right to privacy in this country. And then the High Court, in a case called Leaner Game Meats, sort of gave a little bit of an indication that, well, they might in the future consider extending this area into a right of privacy. Now, the Leaner Game Meats sounds very familiar. This was a possum abattoir in Tasmania. Animal Liberation went there, took some covert footage, handed the footage over to the ABC. and Lena Game Meats tried to restrain the ABC from showing that footage, and they relied upon, as you can see there, 3 issues to stop them airing the footage. Now, Lena Game Meats was unsuccessful on all 3 causes of action to restrain the ABC showing it. And in terms of the first one there, you can sort of see they said it would breach its confidentiality. And the court, and I won't read you the quote, but they're basically saying that whatever happens, well, I'll read you part of it. They're saying that, a person who enters without permission is a trespasser, but that does not mean that every activity observed by the trespasser is private. And what they're saying there is that in some situations, I look at things like if you were counterfeiting money, for instance, behind closed doors, clearly there's a public policy, point of view that, it would be okay for someone to reveal that footage. But more importantly for the feedlot sector, because these operations are required to be licensed, in the abattoir in this case, and obviously feedlots need to be licensed, the information about those operations aren't confidential. And with respect to the issue about the footage being obtained illegally, the court did sympathise with the abattoir here, but they also said, look, the fact that the footage was obtained improperly at the outset didn't taint its use by the fact that it subsequently fell into a third party's hands who didn't actually film it. I think that heartens all the journos in the room, obviously. And then, as I said, the last one there, they go, in terms of invasion of privacy, they said, well, look here, we're not going to give them the relief that they're seeking, but in the future they made it clear that, look, we may consider it. And that's where we get to today. And I referred to earlier this Australian Law Reform Commission report, which is called Serious Invasions of Privacy in the Digital Era, and this is brand new stuff. Came out in June of this year, but it was only tabled in Parliament in September. They've recommended there's the new statutory cause of action for serious invasion of privacy. Now, this has been around in the States for many decades, but in terms of tort reform, and I will not get onto tort reform because I'll have everyone asleep, but it's been many, many years since they've looked at introducing a new tort. So you can see there's 5 elements that need to be satisfied. You can see a lawyer's obviously had a hand in this intrusion into the plaintiff's seclusion. It's a great term. But all of those things that you read there, save for that very last point at the bottom, should give everyone in this room great heart and hope because it's moving in the right direction. But the ALRC, and this is only recommendations, mind you, at this stage, they've erred in my books, and I'll deal with that in closing, in that you can see that it's only going to be actionable by natural people. So corporations will not be able to rely upon this relief. As I said, and I'll deal with that in a little bit more detail and when I'm closing. Now, but they've also said that, and they made a couple of other recommendations. They said that you can have an expectation of privacy even in a public place. And in that regard, they referred to 2 examples, one of which was, everyone would be familiar with the supermodel Naomi Campbell. She sued a newspaper in the UK and said her privacy was invaded when she was photographed leaving a Narcotics Anonymous meeting. So she was in a public place, but they said she still had an expectation of privacy in those circumstances. And they also said, which is important from our perspective here today, is that people should expect less privacy at work, but you still should have an expectation of privacy at work. One of the other recommendations they made was that each of the states presently have surveillance acts, and I won't go through all of them, but there needs to be a homogenisation and so that basically there's uniformity in terms of those surveillance laws across the country. And also, one thing that needs to be made clear is when they do enact these laws or these recommendations, which looks like it's going to be in the middle of next year, they need to, or technologists talk about the fact that today's rare and expensive is tomorrow's commonplace, so the legislation needs to be technology neutral so it can accommodate all technologies moving forward. Now, one of the other reports that was handed down in the middle of this year was from the House of Representatives Standing Committee on Social Policy and Legal Affairs, was a report called Eyes in the Sky, which was just dealing with drones. I won't go into that in any great sort of detail because ultimately a lot of their recommendations were picked up by the Law Reform Commission. But they've made it very clear that there should be legislation introduced to protect against privacy invasive technologies such as drones, and that they also said there should be harmonised Australia-wide surveillance laws that cover listening, optical, data and tracking devices. Now, in 2002, Australia was one of the first countries to actually introduce legislation dealing with the use of civilian drones, and so that was 12 years ago, and there's still only less than 100 licensed drone operators in the country. It's an incredibly bureaucratic process, and which it probably needs to be given, you know, the safety issues that potentially come into play. Now, to become a licensed operator, you need to undertake training and you need to register your drone. Now, for recreational operators, and that's probably what we're going to be dealing with here in terms of animal activists, you don't need a licence. You need to operate the drone during the day. It always needs to be in line of sight. You can't operate it within 5.5 kilometres of an airport, and you can't operate it any higher than 122 metres above the ground. I don't know how they determine that, but anyway, that's the rules. So basically, where do we go from here? And the question we probably need to be asking ourselves here is whether someone has a reasonable expectation of privacy and whether society is prepared to accept that as reasonable. And this has been a fertile area of debate in the US of recent times. A number of you will be aware of the ag-gag laws that have been passed in a myriad of states in the US. Some of them have been overturned. I've had a bit of a close look at most of them, and one really caught my eye, and this is this one here in Missouri, Preserving Freedom from Unwarranted Surveillance Act. And basically that bill prohibits any person or entity from using a drone or other unmanned aircraft to gather evidence or to conduct surveillance of an individual or property. So they go a little bit further there than the ALRC report. Without the consent of the individual, and any information obtained or collected cannot be used as evidence in a criminal proceeding. So, you know, that's got real teeth, that legislation. And when you look at the legislation that the private senators bill that's being introduced by Chris Back, and again, I won't read that to you because you can read it for yourselves, it's maybe a submission that Alpha needs to make to the Senate to maybe consider some of these other laws just to give this Act a little bit more teeth, because at the moment, when he's talking there about imposition of stricter penalties for people who trespass, well, as I think I've alluded to earlier in my seminar, that at the moment, flying over the land doesn't constitute a trespass in law. Now, in terms of low-hanging fruit, unlicensed drone operators need to be conscious of the fact that they're subject to local council bylaws. And, you know, there's a reasonable expectation that major gathering areas for people like football stadiums, beaches, music festivals, that for obviously there's a risk of injury of flying these things around, so you can't operate them there. So given the importance of your operations to local economies, there is the chance, I would suggest, that if you can sound out your local council to see whether there will be a willingness for them to pass bylaws to cover off on these particular issues. Obviously, if you're in a place it's a little bit more built up like Toowoomba, you're probably not going to have as much ability to persuade someone, but if it's a properly rural area, I would imagine you might get a sympathetic ear. And in those circumstances, all the operator will need to do is to show that they've posted a sign on the boundary saying that you can't operate any drones within this facility without the authority of the owners. Now, the activists will have you believe that, you know, and they point to a lack of resourcing as why they're in this space and, you know, why the RSPCA is not doing their job. And to me, that's like a distortion of the facts, because in essence, every government-funded regulator would say that they're under-resourced, but I don't see the ASIC or ACCC putting, you know, listening devices and cameras into boardrooms around the country, you know, without getting warrants in place. So I don't see why these groups think they're any different to anyone else. Now, I'd be the first to advocate greater transparency right across our intensive farming and grazing operations in this country, and there's little doubt that Alpha's been leading the way and is ahead of the curve in terms of most agri-producer groups in this country. But from my point of view, a line needs to be drawn in the sand in terms of having these groups paint the industry in a poor light with selective editing and sensational reporting to urban consumers who are, you know, quite removed from, you know, how our product ends up in the supermarkets and on their plate. Now, as a journalist in The Australian wrote last year, and I won't read that to you, but he was talking about what Jerry alluded to earlier, about the activists entering those piggeries down in Young. And he's right, basically. You know, you can only imagine the howls of indignation from these animal activists if you actually went and started sticking a camera in their own homes, you know, that you'd hear about all their civil liberties being breached, you know. So it's a double standard. But look, this is an area that's ripe for exploitation, and we shouldn't allow it to become the norm that when you go out to work of a day, you have to look up in the sky to see whether there's a drone hovering overhead. So the law needs to catch up with the reality, and the rights of law-abiding producers need to be protected so that they're not eroded any further by people that have no idea what they're talking about and have no skin in the game. Thank you.
Tess Herbert from Gundomain. Trent, just
Feedlot of the Year winner, by the way.
Yes.
Thank you, Jerry. A quick question about the terminology ag-gag laws. Is there a better phrase we can use? Because no one's being gagged.
Well, look, I suppose it's a debate you see online all the time, and I fall into the default position there of referring to what everyone else does. I don't have a view on that. I agree. It gives it a negative connotation, but like everything these animal welfare activist groups, they're very good at coming up with catchphrases that sort of people end up using. So I don't know.
Yeah.
I don't know.
Thanks. I'm Claire from Murdoch University. You were saying that the law needs to catch up. Is there something that producers can do to try and help that along the way?
Well, I was probably having a little bit of a chat to Dougal Gordon last night. In terms of, as I said, that ALRC report, it only deals with the individual, and there needs to be submissions made to them about the fact that most farming operations, most feedlotters in this room, their entities would be owned in corporate structures, partnerships, operating entities, you know. So there needs to be submissions made about the fact that those recommendations will not cover, you know, this industry. And that's probably the way it needs to be dealt with, is, you know, submissions made. And I know Alpha did make submissions to, I think, both those committees, the House of Reps committee and the ALRC. So, but there just needs to be more to point out that there's a gap there, basically.
So, in other words, Alpha needs to get some skin in the game in terms of the policy settings.
Yes.
Yep. All right, we'll leave it there. Trent, thank you so much. Trent Thorne, ladies and gentlemen.